federal government's duty to serve the public interest relies on transparency and accountability to its citizens. However, since the 1970s, federal agencies have increasingly chosen to avoid a public trial and settle litigation behind closed doors. The resulting consent decrees and settlement agreements can mandate terms beyond the scope of the original violation of federal law and can lead to higher costs than a trial. These agreements are nearly impossible to modify or vacate, and in many cases can remain in place for decades. One instance, New York City, their special education program has been under a consent decree, I think, since 1972. This process has influenced a range of public policies across governmental programs in states, counties, and cities, with elected officials inheriting the burden with little knowledge of the mandates or cost. In Alabama, for instance, when former member of Congress, Governor Bob Riley was elected governor of Alabama, he was going over the budget and saw the amount for legal fees and asked what it's for, and he was informed of the number of consent decrees that the state was under, and they were paying out these legal fees, and it was an enormous amount. States, municipalities, industry stakeholders, and taxpayers are often directly affected by the terms of the agreements, but are prevented from participating in the negotiations. In some cases, the settlements are declared to be confidential and the contents sealed without providing any explanation. Unfortunately, there is no uniform standard for record keeping across federal agencies. While some agencies have issued directives to streamline and publish this information, most of the public's access to federal settlement agreement information is primarily issued in the form, as my colleague from North Carolina pointed out, in the form of a press release. It is therefore impossible for the public to determine the comprehensive cost and outcomes of these settlement agreements. This lack of transparency leaves elected officials, agency officials, and the public in dark about the consent decrees that can impact them. Oftentimes, newly elected officials, as I said, from governors to attorneys general to mayors, are sworn in and inherit substantial legal obligations they were completely unaware of before they took office. The Settlement Agreement Information Database Act will address this problem. The bill establishes a centralized and electronic database of settlement agreements entered into by federal agencies. Basic information about the settlement agreements already collected by federal agencies, such as payments and dates, will be available to the public online through this database. H.R. 995 provides long overdue transparency and accountability standards to the federal settlement agreements. I thank my colleague, the gentleman from North Carolina, Mr. Meadows, and the gentlewoman from California, Ms. Hill, for their support on this bill, and urge my other colleagues to support this bill as well. And I yield back.